welcome to the Personal Injury Law Show. This show talks about everything current in the law of personal injuries and obviously of importance to you, the viewer. My name's Tony Carbone. I'm a personal injury lawyer with 30 years experience. With me today I've got John Karantzis, a partner in a law firm in workers' compensation. Good evening, John.
Hi, Tony. Hi, viewers.
And James Richardson, an associate in a law firm in workers' compensation. Good evening, James.
Good evening, Tony. Good evening, John. Good evening, viewers.
Viewers, tonight we've got an update on workers' compensation laws around the country and obviously, more importantly, what happens in Victoria.
However, Tony, before we get to that, what's in the news?
What's interesting is this fellow that won a 16.7 million in Powerball and kept it from his mates at work.
Oh, yes.
John, do you think there's any agenda there? Is it mischievous? Is he...
Big claim, Tony. $50 million winning at Powerball. Now, this person that lives in Geelong, he's won the money, and the next day he's called in sick, and then on the following Monday he's resigned, disappeared, and then one of the co-workers, Tony, has to deliver to him a bottle of champagne for the winnings.
That's extraordinary, isn't it?
Now the Powerball 14, and that's the nickname that's been dubbed, have gone to the Supreme Court of Victoria. The court has ordered that Tatslotto identify the winning ticket, the name, and the monies that were paid out.
Yep.
Therefore, it's a wait and see now, Tony. It's a big claim.
James, this particular fellow that says that he bought a separate ticket and won on his own ticket, what's the test in the courts?
Well, Tony, the test will be whether on the balance of probabilities the ticket that was purchased and that won the money was in fact
his own
ticket.
Or whether it was a ticket for the syndicate as a whole. Exactly. John, there's an extra person. There's a 15th person that come out of a woodwork.
That may take his own legal action against the Powerball 14 and the winner. So it's pretty complicated. But you're right, James. Onus of proof is on the Powerball 14, the people going to court. Yep. They have to show that this ticket was part of the group.
The way the Red, or Gary Barron, the Red Baron here, has gone about it, it's going to raise some sort of doubt, I guess. Well, credibility might be shot. Who knows?
Credibility will be an issue because he kept quiet only until he was found out.
Look, we'll come back to this story. It's going to be very interesting the way it unfolds. James, there's serious concerns that after the fire at the tower in Latrobe Street, La Crosse, that a lot of the towers in the city have been built with cheap materials that don't comply with fire standards. That's a concern, isn't it?
That's correct, Tony. There's some reports that a cheap product called Alcubest has been used in buildings around Melbourne. This product has not satisfied the CSIRO non-combustibility test.
So that's the Australian standards?
That's right.
Yeah.
So there's a deficiency in the Australian standards, and we can have our own, potentially, Tony, towering inferno in Melbourne.
Oh, we have. We were very lucky no one died.
At the Docklands, yes. So liability, Tony, will rest again with the manufacturer and the builders. The
builders, maybe the architects, council for not inspecting and ensuring that there's compliance. There could be multiple defendants.
And foreseeability now has been affected, Tony, because everyone knows about it. So really, they can't say we didn't know about it.
Not only that, the laws are very complicated in this area, James, because there's a lot of statutory regulation and things like that. So who knows? I mean, 170 towers have gone up in recent times. Everyone's going to get inspected. Yeah. It could be multiple millions of dollar claims there.
Or claims in the rectification works of these buildings.
Domestic violence, there's a new twist to all of this now. A lady's taken the husband to court and got awarded $70,000.
Yes, $70,000 award, most likely under the Sentencing Act in the County Court of Victoria, Tony, for the physical assault that her partner forced upon inflicted upon her. Now, Tony, you raised an issue about family law also.
Yeah, look, okay, let me say this. James, when I was doing family law many years ago, the parties agreed to split their money up 50-50, right? Because there was no kids involved. Then she was assaulted multiple times by her husband, so we sued him for assault and battery.
Yes.
The old assault and battery. We got an award of, I can't remember what the amount was, but they came off his 50% share.
Yes.
So she picked up her 50%, which she was entitled to under family law, and got the extra money through an assault in the courts.
So technically, it's worth her while.
Farm accidents, James, seems to be a never-ending saga in terms of trying to ensure that people look after themselves.
yes.
There's an enormous amount of accidents where people die or are seriously injured.
That's right, Tony. There's been reports showing that some 100 people in the last 10 years have died on farms, 50 of which have been work-related accidents, and the other 50 have been in what have been called hobby farms.
Tony, one of the main problems is rollovers on tractors.
Yeah.
They're very dangerous, inherently dangerous vehicles, tractors on a farm. They roll over, they crush the person that's driving them.
Well, the tractors do bounce around and they're on uneven ground.
Exactly.
So the chances of the thing tipping over
Exactly.
is more than someone that's on level ground, I'd imagine.
I know hobby farms and farming in general sounds all idyllic and peaceful and great, but inherently it is dangerous. Everyone out there, please take care on the farms. And again, the employers have a responsibility to provide a safe workplace.
Importantly, Tony, if you are injured during the course of your work, someone dies, the partners of those parties do have entitlements under statutory benefits for
yes.
dependency claims.
Very well said, James. John, this is an area that I'm particularly interested in. I'm part of a Bully Zero board. Stressed out workers and also bullies, they're costing nearly $1 billion a year.
Yes, bullying, it's a no-go, it's not allowed, and stressed out workers, well, you have entitlements.
James, it's nearly $1 billion a year now. It's a lot of money, isn't it?
That's correct. TAL, a large insurance broker, has reported that $1 billion per year have been paid out in bullying claims. It's a reflection of where Australia is moving from a blue-collar to a white-collar work base. But what I say, guys, is that it's an insurance policy and it's there to be used.
That's
Oh,
it.
yes.
That's it. Viewers, we've got to go to a sponsors break. Stay tuned and we'll give you the update on Workcover just after the break. Welcome back to the show. Tonight we're going to be doing an update on Workcover, seeing that at least 50% of all accidents that get compensated in Victoria do arise in a workplace. Is that correct, John?
Yes, Tony, yes.
Yeah. It's a big number. But before that, John, you wanted me to bring up this thing about the orangutan wins rights.
Oh, yes.
This confirms that the human species have come from the
orangutans, Tony. An orangutan, Tony, by the name of Sandra in Argentina, Buenos Aires, Argentina, has been granted the same basic rights as humans, Tony. She's been in lockdown in a zoo for 21 years, and
behind bars,
and she's been granted rights as a non-human subject.
21 years. Does that mean she can sue for compensation too? 21 years behind bars?
She may well be into the future, Tony. Who knows?
Well, she's got rights now, Tony.
All right, so they've said that she doesn't have to be locked up in a cage. So where does she go?
She could be free to wander the streets.
Are you sure?
No.
I'm not sure what happens next. I mean, if the orangutan's been behind bars for 21 years, she wouldn't be able to look after herself, surely, would she? Out in the wild?
You wouldn't have thought so.
No.
As we know, Tony, some orangutans have more common sense than some human beings, Tony.
Not going to go there. Anyway, let's get on to this Workcover update. A lot of these cases do originate from New South Wales, but the principles are very similar.
Exactly.
The first case is Trollan and WD Gel Insurance and Finance Brokers. Very interesting case, 2014 decision. James, what are the basic facts of this case?
Tony, this was a matter where an employee was awarded $700,000+ in damages. The plaintiff worked for the defendant in an insurance broker setting, and she was subject to sexual harassment from her boss. Interestingly, in this matter, it looks like the sexual conduct was only in a very limited space of time. The plaintiff then had some time off work, and the defendant's wife, who was also a director of this company, called her during this time, asked what was going on, and she indicated that she'd been subject to this sexual harassment. She told her not to worry, come back to work and I'll deal with it.
John,
Tony,
some of the allegations were as follows. That he put his hand up the back of her dress and squeezed her bottom.
Yes. Grabbed her breast.
Yeah.
Placing her hand, his hand up her skirt. Tony, lewd acts which were denied by Mr. Gill. Now, this went to a full hearing in the District Court of New South Wales.
Which is the equivalent of our county court in Victoria.
Plaintiff, Ms. Trollan, gave evidence. The judge believed her evidence. She talked about the instances of the groping, the instances of the sexual harassment, how this affected her psychologically. She suffered from post-traumatic stress disorder. She was unable to work. The defendant, Mr. Gill, gave evidence. The judge did not believe his evidence, Tony.
I find it extraordinary. The judge actually found all 12 elements of conduct alleged by Ms. Gill against Mr. Gill were satisfied.
Yes.
I think what was compelling, James, was the fact that there was a complaint to a wife.
That's correct.
Who was also a director.
That's correct, Tony. And look, the wife had made representations that she need not worry, come back to work, and essentially that she would deal with it. But that's not what took place at all.
I'm not even sure if the wife gave evidence, John.
No.
Yeah.
No, that's not my understanding. Yes.
And that would have been pretty compelling too,
I think so. One of the other issues which I found quite interesting, Tony, reading the judgment was the judgment refers to the events after the actual complaint and incident. Now, there was no... the employer, once they're aware of an issue, has a requirement to act upon it.
Yep.
In this case, it wasn't acted upon it.
No.
At all. The wife knew about it, who was a co-director of the company, and nothing was done about it. And that was, again, central to the judgment, Tony. If, for example, the employer had acted upon the complaints, then there may not be a claim, Tony. There could be a pretty good defence. But in this instance...
It just kept going on and on.
The actions occurred and it's kept going along and no redress has been made.
It sounds like he was pretty belligerent in his approach to the whole thing. What's interesting, James, and I want your view on this, assuming it wasn't the company director that was carrying out all these acts of, misconduct, and assuming it was just another employee, the company's still got to act on it, don't they?
Oh, most certainly, Tony. If complaints have been made regarding any sort of conduct at the workplace, the employer is put on notice that the issue has arisen and they're required to do something about it.
Clearly, Tony, and we want to warn and advise all viewers out there, you must complain as to what's occurring. Without a complaint, Tony, you've got no action, do you?
No, not at all.
Especially in psychiatric cases.
Well, the employer's got to be aware that there is a problem.
There is a problem.
Because, that's the foreseeability part of the case.
Exactly. And time again, Tony, we come across clients that have not made complaints.
Exactly.
They've got real bad injuries, but because they have not made complaints, the case is weak.
Yes, they're too scared to complain because they'll lose their job, but as it turns out, then they've got no case.
Exactly.
Significantly for employers, what they must do is that when there's a complaint made, there needs to be an investigation and grievance procedure to manage a complaint, and it has to be followed once a complaint's been made. So employers are on notice because in this day and age, you've got to be so careful. Britt and Cody, James, you want to give us the facts of this case?
Certainly. This was another New South Wales case whereby a worker was successfully able to sue his employer for damages. The facts of the case are interesting in that the actual conduct that caused the injury, which was a fight between the employer and the employee, took place outside a pub, is my understanding.
Yes.
And the court found that this constituted the workplace because of the facts behind the reasons why they were there.
Even though this was after hours?
That's correct. So essentially they needed to go to the pub to get paid, is my understanding.
Yep.
That's where they got paid.
And there was a Christmas party
There was
happening.
a Christmas party that took place afterwards, and
The employees, one of the employees' responsibilities was to drive the employer around.
That's correct. So the court found that it was that the employee had to essentially tag along with the employer at that time. Therefore, it was part of the workplace.
Did he have a choice?
No, he didn't have a choice at all. He had to go with him.
I like the wording of the judgment, Tony. They use the word inducement. The employer induced the employee to come to this Christmas party.
Well, what if the employer said, I don't want to come along? Was that an issue?
Well, he didn't. That's the whole issue. And the court found that the employee felt like he couldn't say, I can't come along. He was induced to go to this Christmas party. It was part of his required work duties.
Even though it was after hours?
Exactly.
That's correct.
Okay.
And even though this was a New South Wales case, I feel that it would be a similar
Yes.
response in Victoria.
And in Victoria, we've had instances, haven't we, Tony, where people injured at a Christmas party.
Barbecues, Christmas parties, sporting functions, everything.
That is in the course of work.
Yep, of course. Viewers, stay tuned. We're going to go to a sponsors break. After the break, we'll take up this issue. Viewers, welcome back to the show. We're talking about all the things that can happen in a workplace that are really, really technical, they're complicated, you've got to get advice, your mind's all over the place. John, how come people, they come to you when the proverbials hit the fan,
Yes.
and at that point in time you're trying to pick up the pieces and sort of backpedal to make sure that the ducks line up. And more often than not, they don't line up.
Tony, invariably we find that complaints have not been made about the actions in this instance. For example, sexual harassment, bullying. Now, if you just ignore it and try to keep on working, well, that's a time bomb. Firstly, for yourself medically, you won't be able to handle it and you'll go off the rails. But secondly, also, if the employer is not aware that there's a person in your workplace bullying you or subjecting you to unfair work practices such as, sexual harassment, teasing, any kind of...
It needs to be documented.
It needs to be documented. How do you document it? By complaining. Complaining to your supervisor, complaining by email. Verbal conversations, I don't think is enough.
No, it's not enough. Not enough.
Because invariably you
need a paper trail.
Invariably you find, viewers, that those supervisors deny that, this worker never complained to me.
No, I had no knowledge.
Exactly.
That's the first thing they say.
Exactly. So if you've put it in email, you've put it in writing to your supervisor and to your employer viewers, then you've got a documented, detailed complaint about what's happening to you.
And it protects and preserves your position, correct?
Exactly.
And in this day and age, where you can actually go to court to get an order to prevent these actions from occurring, you should be doing it, shouldn't you?
Exactly.
And on that note, Chim Garib and Magra Proprietary Limited, what are the facts of this case, James?
Tony, this is another District Court of New South Wales matter whereby a injured party was refused leave or refused access to sue his employer for damages because he was out of time.
And John, the injuries in this case, it sounds to me that they wanted to wait to see how the injury progressed.
There was a prospect that surgery may be in play, Tony, and the worker advised or instructed his lawyers to put things on hold. Well, that's all good and well, but the problem is time keeps ticking, Tony, doesn't it?
So the statute of limitations kicked in?
Statute of limitations kicks in, viewers, which means basically you have a certain amount of time to pursue your entitlements. Once that time has gone, then you have to request to the court an extension of time.
And they're very hard to get these days.
Because you have to show the onus is on the worker to show why should you be given an extension of time, Tony. And in this case, unfortunately, the worker failed to do so.
Well, James, just on the issue of extension, the court said that in the affidavits, the lawyer's affidavit and also the worker, there was no explanation as to why there was a delay.
That's correct, Tony. There was some indication in the affidavits of both parties that surgery was indicated, but what the court said was that there was a period of some 2 years where it was silent on what the delay was about.
And John, in New South Wales, the law's pretty tough at the best of times, correct?
Oh, yes.
So, and you've got to satisfy all these impairment ratings, and
Exactly.
it becomes a...
And viewers, you have a short amount of time to issue a damages claim for your work injuries. So again, you need to act immediately. You should see a lawyer as soon as possible to seek legal advice as to your entitlements.
Yeah, it sounds to me that the lawyer should have taken some action. So I would have thought that Mr. Garrib's next course of action will be probably to sue his lawyers.
That's correct, Tony. And look, unfortunately for this client or this worker, he did satisfy the threshold to be able to pursue his former employer for damages, but it looks like just his lawyers weren't diligent enough to act fast.
And Tony, entitlements, damages, we're talking pain and suffering, which could be worth hundreds of thousands of dollars.
Yes.
And if the worker is not working and has future inability to work, again, that could be worth hundreds of thousands of dollars. So it's a big claim, Tony.
I'd like just to reinforce the words "could be," because a lot of clients turn around and say, "I saw it on the show," and they think they're worth hundreds of thousands.
It's always could be.
That's the exception to the rule,
Yes.
I would have thought, because the majority aren't worth big money in this day and age.
No, because not only do you have to prove, again, an inability to work because of your work injuries, but you have to prove fault liability, Tony.
That's exactly
and
right.
that's the other issue.
Quickly, let's do this case of Worley and State of Victoria. This is a Victorian decision. It's in a magistrate's court, and it's about reasonable management action. Give us the facts of this one, James.
This was a matter that was before the Magistrates Court in Victoria. Essentially, the plaintiff had sustained a psychiatric injury resulting from work. The Workcover legislation in Victoria specifically disallows any compensation for injuries resulting from what's called reasonable management action. What happened here was that a business manager for a school was told essentially that the working hours that she could undertake at school were to be reduced, developed a psychiatric injury, and then lodged a Workcover claim, which was rejected by the Workcover agent.
Tony, these are very controversial cases. From my recollection, this is only the second judgment that's gone against the worker in regards to a defence of reasonable management action. In this case, Your Honour, His Honour Judge Ganane has found that the worker did not satisfy the test, in that the school wanted her to increase her work hours. They went through, and it's detailed.
Process.
They went through the process,
Yep.
and the judge details that in his judgment and finds that that process was fair and correct. Again, they're very tricky cases, Tony. The worker must demonstrate, must show that the process involved was unfair and detrimental to the worker to the point that has caused a psychiatric or medical condition.
This particular plaintiff wasn't a lot of money too. She was on $250,000 a year.
Yes.
So the consequences to the employer if they get it wrong are pretty big, pretty drastic.
Exactly.
So, but viewers, the important thing when you're dealing with these cases is make sure you follow a process, because what happens is the employer's trying to follow their own process to show that you're not acting reasonably. So it's a question of who has behaved appropriate in the circumstances.
Exactly.
James, thanks for coming on board. Viewers, thanks for watching. Go to our website for past episodes. Stay tuned for future episodes. Go to Facebook and Twitter, and always remember to stay safe.